good morning. In the interest of time, we'll go ahead and get started. So welcome and thanks for joining us this morning for our ProAct webinar with Frost Brown Todd. And I'm Jen Galt, the Education Program Manager for ACI. And before we get started, I wanted to remind everyone to please remain muted throughout the program, but we encourage you to keep your camera on if you'd like. And feel free to use the chat feature at the bottom to thank our presenter, ask any questions that you might have, and meet the other participants today. And if you haven't already done so, you can select the speaker view in the upper right-hand corner of your screen. And as a reminder, we will be recording the program and we'll email that out to you once it's edited and ready to go, along with any PowerPoint materials as well for you to refer back to. And again, we're honored that you've chosen ACI as your ProAct resource today, and we look forward to a great presentation. So now I would like to turn it over to our Executive Director, Jordan Vogel, for just a couple minutes, and then he'll turn it over to Kat from Frost Brown Todd.
Thanks, Jen. Good morning, everybody. My name is Jordan Vogel, and I am the Executive Director of ACI. And for those of you who actually may be new to ACI, I just wanted to say hi and welcome you to today's webinar. It's all about the PRO Act and rewriting America's labor laws. So just as a quick overview, ACI is a trade association that serves the commercial construction industry. We've got over 500 members, and we serve them by delivering workforce solutions that solve talent challenges, and engaging in industry advocacy that removes obstacles and creates a climate of growth, and by providing networking opportunities where meaningful connections can be made. And it's that advocacy piece of work where this webinar, it's still kind of early. Anyway, where this webinar lives. So I wanted to take a quick moment to double click on advocacy at ACI, and then I'll ultimately end with a little request, if you wouldn't mind. So ACI engages in advocacy efforts for the commercial construction industry, and the efforts that we engage in are designed to drive policy decisions and legislation that remove obstacles and foster a growth environment for the industry. Also, it's to ensure that the voices of our members and our industry are heard and considered. And finally, advocacy also includes promoting careers in construction. Additionally, and interestingly enough, for those of you who don't know, ACI is Ohio's Associated General Contractors, so AGC's official Cincinnati division. And in that capacity, we both house AGC and we act, excuse me, as the negotiating agency for contracts between unions and contractors. By the way, also important to know, AGC and ACI proudly serve both open shop and union organizations. And in fact, excuse me, today's webinar is a direct result of the ACI-AGC partnership. My colleague, Rich Farr, who's on the call, I just saw him somewhere, is the Vice President of Legal Affairs for Baker Construction Enterprises. He's also the Board President of AGC Cincinnati Division. And it was actually Rich that suggested we present on this topic. So there you have it. We're doing a lot on the advocacy front. We want to do more. And because it's our region's construction industry, or for our region's construction industry, which means most of you on this call, here's the request I referenced. If you've got feedback or suggestions on what you would like to see ACI focus on when it comes to advocacy for you and for the industry, I want to hear from you. I'm going to put my email in the chat, so you'll have it handy. And with that, I would like to turn things over to Kat Burgett, who's an attorney with our good friends at Frost Brown Todd. Kat has deep labor and employment knowledge and experience. So I think you're in, excuse me, allergy is killing me today, for a great session. With that, over to Kat.
Perfect. Thank you so much, Jordan. It's very great to be here with you all. As Jen said, if as we're going through this, you have questions, please feel free to put those in the chat or unmute yourselves. There's no need to hold any question to the end. Feel free to blurt it out as you go. I'm going to share my screen so that we are looking at the same thing. And I will assume that if you all can't see a PowerPoint, someone's going to start jumping up and down and screaming. So we're here to talk about the PRO Act in large part because I want you all to share part of the nightmare that I've been living with when I think about the PRO Act. And so that you can be very popular at cocktail parties if we ever get to have cocktail parties in person again. When we think about the PRO Act, I could not, I think, sum it up any better than Richard Trumka, who's the current president of the AFL-CIO, did when he called it a game changer. because the PRO Act is exactly that. It is intended by purpose and design to upend the labor laws in this country. And I will admit to you that I feel a little bit guilty about this. I have been practicing labor law for over 13 years now, and almost that entire time, I have been arguing that we need to update our labor laws. For those of you who don't know, our primary labor laws were enacted in 1935. That was a really long time ago. It's before there was a Superman. So when you think about how we're trying to fit laws from 1935 into our reality today, they don't fit. And so I've said we've needed to update them. I did not mean the PRO Act. It does a lot of things to really change the balance of power and the way labor laws exist in this country. For those of you who have had to deal with unions, which is most of you, you know that the National Labor Relations Board is intended to stand between employees and employers and unions, and to make sure that employees have a choice. Do they want to belong to a union or not? And the PRO Act changes that. It removes, in my opinion, that neutrality. When you look at the way some folks have responded to it, the U.S. Chamber of Commerce talks about how it undermines workers' rights. It disrupts the economy. It takes away individual rights. The National Retail Federation has referred to it as the worst bill in Congress. I haven't read every bill in Congress. I've read this one, all 56 pages of it, and I can tell you that I do not agree with it. So where do we stand with the PRO Act? The PRO Act stands for protecting the right to organize. I think by the time we get through this presentation, you'll agree that it does a bit more than that. A version of the PRO Act was passed in 2020, but the Senate didn't take it up at that time. It was then passed by the House again on March the 9th of 2021. That was a 225 to 206 vote. It did change a little bit from the prior version. There were some more things added to it in 2021. It primarily amends the National Labor Relations Act, although it tinkers in a few other areas as well. It faces, for now, an uphill battle in the Senate. Unless those Senate filibuster rules changed, at least 10 Republicans would have to support the bill to send it to President Biden's desk. Joe Manchin from West Virginia would also have to support the bill to send it to President Biden's desk. So when you hear a lot of the commentary about removing the filibuster when they're talking about minimum wage or some other initiatives from President Biden, this would be on that list. This is one of the things that could be impacted by removing the filibuster. So a summary of what the PRO Act would do, and no, I'm not making any of this up. The first one's directly attributable to you all and things that really could impact the way you do business are the rules related to joint employment and independent contractor status. So a lot of you will remember during President Obama's administration, there were a couple of cases that came out of the National Labor Relations Board relating to joint employment. The big one was Browning-Ferris. And the result of the Browning-Ferris decision was that basically, if you had the authority to look at someone else's employees, you might be a joint employer of that employees. And I'm being a little flip, but it was almost that broad. And when President Trump's board came along, they did away with that Browning-Ferris decision, and they said, look, we really only want to charge people with being joint employers when they're actually joint employers. The PRO Act would take us back to the rule under Browning-Ferris, right? And that rule states that if you have the ability to have reserve control, right, over somebody else's employees, right? So it's not just that you can set the terms and conditions of the employment, and you do, but if you have the potential to, even if you never use that potential, you could be a joint employer with someone else in regards to their employees, right? So we go back to the future of it. And the PRO Act goes so far as to say that there is nothing in the PRO Act that would prohibit the board from finding that reserve control by itself is enough to make two entities joint employers. So why does that matter for your purposes? If you're found to be a joint employer with someone else, you can be liable for that entity's unfair labor practices, and you can also be dragged to the bargaining table to negotiate over terms and conditions of employment. So think about all of the different ways, the reality when you're on the site, and how often you may have indirect or reserve control over someone else's employees. right? You could find yourself in some joint employment relationships and having to negotiate with other people or be liable for the mistakes that they happen to make, right? Similarly, one of those things that we're going back to the future for is independent contractor. So we have had similar issues with independent contractor status. We've flip-flopped over the years. It seems like every governmental agency has its own independent contractor test, from the Department of Labor to the IRS to the various states that we are in, and of course, the National Labor Relations Board. And the board has bounced around a little bit, trying to figure out when someone is an independent contractor and when they are an employee. And the PRO Act adopts what is known as the ABC test. The ABC test for independent contractor status comes from California. And I kind of feel like maybe that should tell you everything that you need to know about the ABC test. The way that works is the A, that in order for someone to be considered truly an independent contractor, they have to be free from control and direction in connection with the performance of the service, both per the contract and in actual fact. So they get to decide when, they get to decide how, and they get to decide who. We don't get to tell them how to do their jobs, right? So for example, if I were having a new roof put on my house, I'm not going to climb up on the roof and tell the roofers how to put that on, because wholly ignorant when it comes to that. They are independent contractors, right? The B in the ABC test is that the service has to be performed outside the usual course of business for the employer. So it can't be what you do. What this person does for you cannot be critical or integral to your business, right? And then the C, the individual has to be customarily engaged in the business and the way the business works. So this is what they do, right? I hire a lawn care company to come manage landscaping. That's what they do, right? A and C aren't the hard ones. The really hard one and the sticking point that we see a lot of litigation over out of California is number B, that it has to be outside of the normal course of your business. There will be a lot of fights about what that means, right? So for example, if you have computer employees who make sure that all of your electronic systems are up and running and that you can do everything you need to electronically, are they critical to your business? Are they outside of your business? Are they ancillary to your business? Or do they make sure that you can run the business the way that you need to? So there will be a lot of fights about what that particular thing means. And I'm sorry to say, I believe it means we'll be borrowing a lot of law and case decisions out of the state of California, which is never where you want to find yourself. Not only do we have these changes in independent contractor status and joint employment, but the PRO Act makes it an unfair labor practice for an employer to mistakenly, even unknowingly, tell an employee that they're not an employee for purposes of federal labor law. Right? So the way it stands now, you're allowed to make a mistake, right? And you all have seen the cases, you've read the newspaper articles, that sometimes employers make mistakes when determining whether somebody is an independent contractor, right? The PRO Act removes that ability to make a mistake. So it is an unfair labor practice to truly just tell someone that they're an independent contractor if the board finds they're not. So there's a lot of opportunity for liability surrounding those two. The PRO Act also tinkers a lot with strikes and with right to work laws. So for strikes, for the first time ever in the history of this country, or for a very long time, the PRO Act would permit a secondary strike. And so a secondary strike, sometimes called a solidarity action, is a strike against another employer. So it could be downstream, it could be upstream, it could be totally unrelated to you. So by way of an example, if employees at a steel company strike, and you buy steel from that company, your employees could strike as well to prevent you from buying steel from that company, right? So solidarity action or a secondary strike. These are fairly common in the rest of the world. We don't have them here. And the PRO Act removes that prohibition and says that secondary strikes are going to be allowed, right? So you could face a strike not based on what you do, but based on what somebody else does. The PRO Act also permits intermittent strikes, slowdowns, and partial strikes. And we've seen a lot of these in recent years, particularly in the fast food arena, where all of the employees of Burger King or McDonald's or Arby's will walk off the job for one day. They're allowed to do that once, right? A strike is allowed to be a day long, but if you had people walking out every other day or for 6 hours here and 4 hours there, that's not allowed under our current labor law. And the PRO Act would change that. And so what it means is that you could legitimately have people striking every other day, only on Fridays, only on Mondays. And you can imagine how difficult that is to plan around. If employees are going to strike and they're going out on strike and you expect it to be a long one, you can plan for that. You might not like it, but you can plan for it. You can have a contingency plan in effect. You can have temporary workers. You can have it set up so that you can still operate. But it's very difficult to plan around intermittent strikes or partial strikes or slowdowns where something used to take 5 hours and suddenly it takes 50, right? Hard to deal with that. You also would be prohibited from bringing any kind of a claim against the union for these kinds of strikes. Right now you can bring an unfair labor practice charge against the union if they engage in any of these, and obviously you will not be able to do that moving forward. It also changes what we can do with striking workers. If any of you all have ever lived through a strike, and I'm super sorry if you have, you will know that there is a difference with how we can treat striking workers based on whether the strike is caused by economics or whether the strike is caused by an unfair labor practice against the employer. If it's an unfair labor practice strike, you cannot permanently replace those employees. If it is an economic strike, so your folks walked off the job because they want to be paid more, then you can permanently replace those employees. And the PRO Act removes that ability to permanently replace economic strikers. And as you know, if you've gone through it, that's one of the big levers that an employer has when convincing employees to either not strike or to come back from strike is not being permanently replaced. So losing that is kind of a big deal. On top of that, the law prohibits what's known as an offensive lockout. So if you all know the difference between a strike and a lockout, strike is when the employees decide to leave, and a lockout is when we tell them they're going to leave. And we literally lock the doors and don't let them in. For years, employers have been allowed to offensively lock employees out to use as a negotiation tactic to get the employees to accept perhaps a last best final offer or to accept whatever has been on the table. And these have been allowed under federal labor law since 1965. And the PRO Act removes them. It says you are not allowed to offensively lock employees out. The only thing that is left is what's known as a defensive lockout. So if the employees strike, we're then allowed to lock the doors. So that would prevent employees from returning if they wanted to, if we weren't yet ready. But the offensive lockout goes away. Beyond strikes, the PRO Act attempts to eliminate right to work laws nationwide. So I don't know how many of you get to deal with right to work a lot. Currently, 27 states have right to work laws. And what right to work is it's a little bit of a misnomer, and there's a lot of misinformation about there. But as you all know, you can't have a true closed shop, right? Where all employees must be members of a union, right? You could have a shop where they don't have to be members, but they have to pay agency fees, or sometimes called core fees or core dues, right? So as long as an employee is paying money to the union, in most states that is allowed, right? And we think of that as a union shop. Right? So in a traditional environment, in a manufacturing environment, I might have 100 employees. I have mandatory member or union membership. What that means is 50 folks might be a true member, 50 folks might just be paying money to the union, but they don't have a membership card. Right to work does away with that requirement that someone pay money even if they don't join the union. Okay? So when you look at the right to work laws, it says you can't be compelled to pay the money. Unions hate those because they believe it creates a free rider problem. Why would I pay money to the union if I'm going to get the benefits of belonging to the union? They still have to represent me. They still have to negotiate on my behalf, but I don't have to pay the money. So the PRO Act does away with all of those right to work laws. And they say we can go back to the system that exists, frankly, like what we have in Ohio, where employees are going to be required to either join the union or pay money to the union, those core fees or agency fees. That makes sense. So that would be a huge change for a lot of states and sort of change that balance of power. The PRO Act also tinkers with the election process. If any of you all have gone through an election where a union comes in and petitions to represent employees, they work kind of like a political campaign. And there's a petition, there's filings, there's campaign material on both sides, and then there's votes. And we have largely conducted elections the same way since 1935. And this would change that in a big old way. First, it changes the time frame. So you all may remember under the Obama administration, a lot of conversation and talk about quickie elections, where we used to have 6 weeks or more from the time a petition for representation was filed until the election happened. So lots of time to get your ducks and your geese in a row and make a good case as to why employees should not vote union. It's gotten a lot shorter. So it's now around 20 or 30 days after petition. The PRO Act requires that the pre-election hearings be held no later than 8 days after the notice of the election was served, and that the election hearings, post-election hearings, be held no later than 14 days after objection. So it tightens everything up so that from the time you get to the petition to the time the vote happens, the employer doesn't have a lot of time to put together a campaign, respond, and help educate employees about what joining a union really means. It makes it a little more complicated for employers because if you've gone through this process, you know that one of the big tools that an employer has to share its feelings about a union is through meetings with employees, right? These are our employees, we are paying them, we get to tell them what to do. And so very often we will have them gather together in one space so that we can share with them what it means to be a union, facts about the union that is petitioning, all of those things. They're sometimes called a captive audience meeting, because the employees are in fact captive in our location. The PRO Act makes captive audience meetings unlawful. So even though they are our employees, and even though we get to pay them and we get to normally tell them what to do while they're being paid, we cannot require them to come to meetings to talk about union stuff or to learn about unions. We can invite them, but we cannot require it. The PRO Act also removes the employer as a party really to petitions. So the way it works now is a petition gets filed, the union is a party, employees are a party, and only the employer is a party, right? Because we're talking about representation of our employees. The PRO Act removes an employer's standing as a party to any of those representation proceedings. So we are impacted by the decisions, but we don't get a say in those decisions. And one of the big decisions that an employer would want to have a say over is what unit we're talking about. So it is the person who files the petition gets the first bite of the apple of saying who's going to be in that bargaining unit. And typically a union is going to want to go for the largest bite of the apple that they think they can win. Sometimes that bite of the apple is very small, right? So we saw something come about during the Obama administration that we called micro units, where a union would come in and attempt to represent 3 guys in maintenance, 4 folks in clerical, right? These micro units. And employers railed against that and said that doesn't make any sense. I mean, all of these employees are kind of the same. And if we're going to have a unit, it should be bigger than 4 or 3, or even in some cases 2. And the board now sort of codifies the concept of a micro unit. And they say that we are going to put people together if they share of a community of interest, right? And we're not going to include anybody else in that group proposed by the union unless those other folks share an overwhelming community of interest, right? So you have to be able to make the case that there is functionally no difference between the group proposed by the union and who we would propose that it be, which can be very difficult, right? That use of the overwhelming word makes it a tough hill to climb. We also changed the way we're going to vote. And this is fairly timely with what we are seeing happening across the country. The way most elections have happened since 1935 is in person. There is a ballot box and employees show up and they mark their ballot and they drop their ballot into the ballot box, and then those ballots are counted by a member of the National Labor Relations Board, not the board itself, but of the agency. And here since COVID, we have seen some more electronic elections or mail elections, right? Because people can't come together. And so everyone has gotten more comfortable with the concept of mail elections. And the PRO Act specifically permits mail elections electronic elections, so some sort of electronic means. It even permits telephonic elections, which is a little bit scary because how do you verify that someone is who they say they are on a telephone? Every time we turn around, our local news are telling us about scams that happen on telephones from people pretending to be folks they aren't. So the concept of electronic or mail or telephonic elections could be very scary and could be a big game changer when it comes to verifying the results of an election. The PRO Act also brings back what's known as a blocking charge. This is one of those things that existed and went away, and now it could come back. And a blocking charge is in the middle of an election. If the union files an unfair labor practice charge against the employer, they could basically stop the election from happening, right? And so these are sometimes used offensively. Right? I feel like the tide is going against me and I don't want the election to happen because I think I might lose, so I could file this unfair labor practice charge and everything's going to be at a standstill until that ULP is decided, which could be years, and then we go back to the election. So it gives the union time to right the ship or turn that aircraft carrier or however you want to look at it. And the PRO Act brings back that concept of a blocking charge. It also changes what happens at the end of the election. So under the PRO Act, if the union wins, it wins, and they are represented and you have to bargain with them. If the employer wins, however, and the board determines that the employer committed a violation of the National Labor Relations Act, it can set aside the election and certify the union as the bargaining representative of the employees and force the employer to bargain. So it doesn't just necessarily get a new election. And the way this would work, it's known as stealth card check. If you have gone through an election, there is an authorization card that unions are required to have employees sign so that they can file the petition, so that they can get the election. They're required to have at least 30%. If they have over 50% is when we could find ourselves in this situation. So if 51% of your employees signed one of those authorization cards and the board found some reason to set aside the election, that is when they would go ahead and say, based on the card check, a majority of employees want to be represented by the union, and so we're going to say they are now represented by the union, and that decision is going to hold for 2 years. The issue with that comes from the fact that when unions get employees to sign the card, they typically do so by saying something along the lines of this. Hey, just sign the card. Signing the card doesn't mean you're going to be represented by the union. If you sign the card, all you're saying is that you want an election. And why wouldn't you want the opportunity to learn about unions and then have a say in whether someone's going to be represented or not? You can always vote no, just sign the card, right? So folks do that, they sign the card, and you could end up represented by the union whether they wanted to be or not, right? It's a pretty big change. The PRO Act also changes things around whistleblowers and notices and unfair labor practice charge. It extends whistleblower protections to employees who report violations of the Labor Management Reporting and Disclosure Act. It makes it so that it covers employees of employers as well as employees of labor unions. So they've expanded some of those whistleblower protections. It requires the National Labor Relations Board to address requirements for posting notices in languages spoken by the employees. So we are all fairly comfortable with the fact that when we post notices, we may be posting it in both English and Spanish. But this is going to take a broader look at all of the languages that might be spoken by your employees and have you post notices in all of those languages, which depending on your workforce means you could use a really, really big bulletin board to have all of those notices that are going to be up there. It also goes back and requires employers to post notice about an employee's Section 7 rights. So an employee's Section 7 rights are those rights that an employee has to join a union, to argue collectively, to ask for better terms and conditions of employment. And we are used to posting requirements. I mean, somewhere in your job trailers, you have requirements for Title VII and OSHA and workers' compensation and minimum wage, and the PRO Act would put labor rights on that same bulletin board. keeping in mind it would be labor rights in English, Spanish, and any other languages spoke by your employees. This is something that the Obama board tried to require, and the DC Circuit Court of Appeals struck it down and said the board does not have the right to force employers to just out of the gate put these notices up. And so this would give the board the right to require employers to do that. Another big change would come in the form of remedies and damages for unfair labor practices or for ignoring board orders. So the first big one is that the PRO Act has the option of having the board impose penalties of up to $50,000 for a violation, or if serious economic harm is at play, or if the board thinks that there are repeat actions defined as the same kind of thing happening within a 5-year time span, that could go up to $100,000, right? So automatically an unfair labor practice charge just got a whole lot more expensive because you're looking at $50,000 to $100,000. It also changes a rule that we have from the Supreme Court that an undocumented worker isn't eligible for back pay awards. And that has been settled precedent for a while, and it would undo that and specifically state that neither an employer nor the board can evaluate someone's legal status to work in this country when determining whether they are owed back pay or any other kind of monetary damages under the Act. One of the big changes is the PRO Act removes the offset rule for back pay. So we are all used to, because of litigation we've gone through, or just sort of the way that we've lived our lives, we have this understanding that a remedy is going to be a make whole remedy, right? So that you're going to be no worse off at the end than you would have been, which means that when we look at a back pay amount, we subtract money that the employee earned by working in another job. That ended up being sort of a de facto mitigation rule, and employees required to mitigate their damages. They need to look for work, they need to accept a reasonable job, they need to earn money. They can't sit at home waiting for a damages award to come in. And that's the way we look at Title VII, that's the way we look at discrimination and harassment, that's the way, frankly, that we look at most damages awards. The PRO Act removes that, right? That has been in effect under labor law since 1941. And it absolutely gets rid of it and states that you have to give a full back pay amount regardless of any mitigation efforts and regardless of any money actually earned by the employee. So it almost acts as a bit of a windfall for employees. They could go get another job, perhaps making more money than they were before, and then still get that full back pay amount. It also changes things in that, generally speaking, under labor law, there's no real concept of punitive or compensatory damages, right? We want that make whole remedy, right? We want to bring someone to where they would have been. But the PRO Act adds all of those other categories of damages back in. So there can be punitive damages, which are intended to punish you. There can be compensatory damages, which are out-of-pocket costs. It can add front pay for up to 3 to 5 years. There can be consequential damages. It also adds in double liquidated damages. So they will take that back pay amount and double it. So all of a sudden, unfair labor practices just got pretty expensive if you're eventually found against you. If the board finds against an employer and imposes some sort of an order, there would be a $10,000 per day penalty for ignoring the order. So the way it works right now is a board's order is not self-enforcing. So if the board wants to enforce its order, they have to go to a court, and then the court has to enforce it against the employer. So an employer can, if it wants, ignore the board order for a time. Under this, it changes that. So you can still ignore it. You're just going to pay a $10,000 per day penalty. Right? It also tinkers with some 10J injunction stuff. The board has the option to seek an injunction against an employer to maintain the status quo if the board really thinks that there's something terrible going on. This has not been something that historically was used a lot. It became a little more common under the Obama administration. It became very uncommon during the Trump administration. And under the PRO Act, 10J injunctions would get a lot more attention. First, The PRO Act makes it so that they get priority effect. So they get that mandatory treatment. They come before anything else. So if the possibility for an injunction comes in, folks at the board are going to drop what they're doing otherwise and pick up that injunction and try to figure it out. It also, the PRO Act narrows the federal court's ability to deny a request for an injunction. So if you've ever had to deal with an injunction, you know that one of the requirements to get a court to give you an injunction is you have to prove a substantial likelihood that you're going to win on the merits, right? So you really have to show that you're going to win. This changes that. And instead of that substantial likelihood that you're going to win, it says that a district court cannot deny the board's request unless there's no reasonable likelihood of winning on the merits, right? That's kind of a huge difference. Like, yes, I'm absolutely probably going to win too. Well, it's not objectively unreasonable that I might win. That's a big difference. So that is a big standard, and I think will result in a lot more of these kinds of actions being brought. And we see them being brought in things like, no, you can't fire that employee because we want to maintain the status quo. No, you can't change terms and conditions of employment. We want to maintain the status quo. No, you can't shut down and move your business to North Carolina because we want to maintain the status quo. So 10J injunctions can be very broad and they can be very disruptive to employers. Another big change you have, do you see what I'm saying? I'm not making any of this up. Comes with first contracts and withdrawals and directors and officers liability. If you all have ever negotiated a first collective bargaining agreement with a union, you know that it can take forever. The average length of time right now for a first contract is a year, right? Because you're starting from scratch, right? Creating this brand new document that's going to govern everything, and it can take a while. Sometimes contracts never happen, right? So you can go 1 year, 2 years, 3 years, and you still don't have that contract. The PRO Act aims to change that. So it requires the employer and the union to begin bargaining within 10 days of a written request from the union upon being certified as the bargaining unit representative. So the union makes a request and you have 10 days to sit down and start bargaining. If no agreement is reached in 90 days, so 3 months, one summer season, then either party can request the assistance of a federal mediator. After 30 days, if there's no deal, then it goes to arbitration. And that's a 3-member arbitration panel. 1 member of the panel is appointed by the employer, 1 member is appointed by the union, and 1 member is intended to be neutral. And then you have an arbitration in front of that panel. And then the panel renders a decision within 120 days. That decision is binding for 2 years. So it takes that process, shortens it down, and forces you into binding arbitration. Binding arbitration like this is something that public sector employers have been dealing with in the state of Ohio for a very long time in terms of police contracts, fire, dispatchers, folks who aren't allowed to strike. And I think the experience, if you know anyone who works in local government for municipalities, ask them how they feel about mandatory binding arbitration and conciliation. They will tell you they were not huge fans of it because you have this third party who's dictating to you how much you have to pay someone, what kind of terms and conditions of employment that person has to have, right? Takes that out of your hands. That decision from the arbitration panel is based on 5 factors. 1, the employer's financial status and prospects. So can you afford to pay more? They're going to look at the size and type of your operation and business. They're going to specifically look at the employee's cost of living. They're going to look at the employee's ability to sustain themselves, their families, and their dependents on the wages paid by you, and then the wages and benefits other employers in the same business provide to their employees. And those are the factors that are relevant when determining economic things, right? So that has the potential to inflate wages paid to employees. Employers beyond that would also be barred from withdrawing recognition of a union, anticipation of a union contract. The PRO Act specifically states that the only time an employer is allowed to withdraw recognition from a union is if there is a decertification election, right? So until you get that decertification election and the votes come in, even if you have reason to believe that the union no longer enjoys majority status, you have to continue bargaining, you have to continue recognizing that union. The PRO Act also narrows the definition of a supervisor. Under the current definition, generally speaking, we are allowed to classify someone as a supervisor if they assign work to others, right? Because they could act as a supervisor. The PRO Act removes the word assign from the definition of a supervisor. It also removes the words responsibly direct employees, and it adds in a requirement that someone act as a supervisor for the majority of the individual's work time. So there are a lot of folks who might be considered leads, who might consider frontline supervisors, who will no longer fit within that definition of supervisor, and who may be forced into a bargaining unit, or may no longer be sort of acting on the employer's behalf. The PRO Act also creates personal liability for the civil penalties for directors and officers. So directors and officers of the company could be held personally liable for some of those damages that we talked about if the director or officer had established the policy that led to the violation, or they knew about it and could have stopped it, right? So considering the fact that a lot of what we talk about, employers will take an action thinking they're allowed to do it, the board will find out that they, or decide that they weren't, and then impose these penalties. Under the PRO Act, directors and officers could be personally on the hook for those penalties, right? We've seen this kind of thing in Ohio before. If you'll recall, for harassment and discrimination claims in Ohio and in other states, sometimes supervisors could be held individually liable for that. Our state law in Ohio for harassment and discrimination just changed to remove that. The PRO Act would bring it all back again for unfair labor practice charges. Another thing it does, I am certain that you all have seen news relating to whether an employee can be required to submit their claims to mandatory binding arbitration. These kinds of agreements have been around for a very long time. A lot of you are subject to them for your credit cards, for a number of things, right? Like arbitration provisions just pop up everywhere. And it's something that employers started doing, sending things to arbitration and requiring that there be a class or collective action waiver, right? Saying you have to send it to arbitration and you can't join together. These largely came about to help deal with some of the costs associated with class and collective actions for wage and hour violations, minimum wage and overtime. The National Labor Relations Board under the Obama administration took great dislike against these kinds of class and collective mandatory binding arbitration provisions and started trying to strike them down. And it went all the way up to the Supreme Court. And the Supreme Court said, no, like this is a private contract, and under the Federal Arbitration Act, like these are fine, and we're going to allow them. The PRO Act would amend that and state that no, you can't have them, you can't require employees to sign them, you can't force them to live with that. So that would change a lot of contracts and agreements that employers have with their employees. Right? It also tries to definitively answer what access employees have to an employer's electronic systems. This is one of those things that has flip-flopped back and forth with every administration. And the question is, can an employee use, say, your email system that you provide to the employee to engage in union organizing activities? And employers, for a whole lot of reasons, say we don't want employees using our email, our cell phones, our tablets, our systems to engage in union business or to organize for the union. And this has gone back and forth whether or not you can, whether you can't. Where we are right now, very recently, under the Trump administration, is that an employer can prohibit employees from using their systems. The PRO Act changes that and states absolutely unequivocally, employees are entitled to use employees' email, cell phones, laptops to engage in union activity. If this goes into effect, it's a bit of a sticky wicket for employers. So as you know, we are required to sometimes monitor our employees' email and cell phone use, right? We might have to gather up emails in response to discovery requests or subpoenas, right? We're also prohibited from federal law from spying on an employee's union activity. So how do we monitor to ensure compliance or to respond to discovery without also spying if employees are using our email systems to engage in union activity, right? So that's going to be something that could be very difficult to work out. The PRO Act also creates an entirely brand new whistleblower program for violations of federal labor law. It has a 180-day statute of limitations. It is run through the Department of Labor. It has all of the same damages that are also covered under the other stuff that we've talked about, including attorney's fees. And there is an interesting provision that an employer or union who loses a whistleblower action is responsible for all of the costs and fees of the other side related to that action. And you might say, well, what happens if it's a frivolous claim? Well, the PRO Act has answered that for you. And if an employee files a frivolous whistleblower claim, they too are responsible for the attorney's fees up to a cap of $1,000. And I'm not sure what legal service you're going to get to defend the whistleblower program capped at $1,000, but know that that windfall is waiting for you in the event of a frivolous claim. And just for kicks and giggles, rights under that whistleblower program cannot be waived. So when we think about some of the waiver of actions, separation agreements, all that kinds of things, this goes in that category of things that an employee cannot waive. So some miscellaneous kinds of things is if that wasn't quite enough to make you the talk of the town at cocktail parties, the PRO Act also seems to eliminate the ability of an employer to negotiate to impasse and then implement their final offer. And that has been a tactic that employers have had forever. And I say seems to because nobody is talking about this. If you go out and you look at all of the media and the scholarly articles about the PRO Act, this one seems to be flying under the radar. But the PRO Act amends the definition of good faith bargaining by adding a duty to maintain current wages, hours, and working conditions, which means if you were required to maintain them, then you would never be able to get to impasse and implement. It also provides that an employer's duty to bargain continues absent decertification of the labor organization, which means you always have to be bargaining. You have to maintain the current status until there's decertification or an agreement. Whether it would be interpreted that way by the board, I don't know. Whether it was intended to have that effect by the people who wrote it, I don't know. I suspect, but I don't know. But it could pretty fundamentally alter the way things eventually get settled out. Could also mean that employees could be stuck with current wages and hours and terms and conditions of employment for years if the union and the employer can't come to an agreement. The PRO Act also permits hot cargo agreements. So a little bit of a history throwback. Prior to 1959, it was perfectly legal for employers and unions to negotiate articles in their collective bargaining agreements that prohibited an employer from handling or working with any product coming from another company with whom the union has a labor dispute. So, dear company X, I have a labor dispute with company B, and so I don't want you dealing with company B at all to help put pressure on company B to give in to my demands, right? Congress, it really came coming out of the transportation industry. Like these kinds of agreements were so powerful in the context of the transportation industry that Congress would have changed the law and said, look, we're not going to have hot cargo agreements. It's too disruptive to the economy. The PRO Act lifts that sanction and hot cargo agreements would be allowed again. The PRO Act also creates an individual right of action, right? So right now, the National Labor Relations Board is the enforcer of federal labor law. An employee, for the most part, can't sue privately because they think an employer engaged in an unfair labor practice. There's a small caveat known as a 301, but for the most part, it goes to the National Labor Relations Board. And the PRO Act changes that, and it adopts a system not unlike what we're used to at the EEOC or any of the state agencies, where if the regional office decides to not issue a complaint against the employer, then employee would have that right to file a private action against the employer. The federal court would be empowered to order the same beefed up remedies that we saw with consequential damages and punitive damages, and employees would be eligible to get the attorney's fees. We also have the persuader rule. So This may have been something that you heard about during the Obama administration. It was struck down by the federal courts. Basically, the persuader rule is that employers have to disclose their financial arrangements with management lawyers or consultants regarding virtually any advice received in the area of union organizing. Obviously, that's very complicated because most law firms do not want to disclose all of their financial arrangements. These are very onerous forms. I don't know if you all can hear that. My computer's making a noise. It will go off in just one GIF.
I can't hear it. I think it's okay.
Okay, perfect. It's letting me know that my office phone is ringing right now. There's just no escaping the office. So the persuader rules could come back, which will impact just the way law firms interact with their clients in this space. Another sort of tricky thing that is flying under the radar when folks talk about the PRO Act is that the PRO Act establishes that it is the board who establishes conclusive facts upon which courts must rely. So right now, courts have some discretion, right? Sometimes a de novo review, but they can look at the facts. And this says, no, right? It is the board that establishes the facts, and you, the court, must rely on those, right? Which changes that balance of power between courts and the board. So what does all of this mean for you? Next steps. So if it looks like the PRO Act is going to pass, and you'll begin seeing that, right? Like it's going to have to be taken up in the Senate. It's probably not going to happen unless the filibuster rules change. Review contractual arrangements, right? Look at any opportunities that someone could say that you are a joint employer with somebody else. How do those things work together? And is there any way to build in separation between you and another employer, right? Review that. Look at your contractual arrangements with independent contractors. Is there any way to ensure that you correctly have classified folks as either an employee or a contractor? That you have built into those agreements that they decide the who, the when, the how, right? That they are their own business, that they are licensed to do business, right? That there's truly that independent contractor arrangement. Consider union awareness training. I say union awareness, not union avoidance, because when that gets leaked out into the universe, it's not often great, but union awareness training, even if you already have a union. Make sure that your frontline supervisors, that folks understand what an unfair labor practice is, how to avoid it, and what their obligations are under federal labor law. Because as you've seen, the remedies for an unfair labor practice have gone up dramatically, and you try to want to avoid that, right? Take a look at your insurance, right? If director and officer liability is going to be a thing, will insurance companies begin having a specific rider for this? Could there be a policy for this? In the same way that we've seen employment practices liability insurance sort of explode as a potential for insurance, does this need to be something? Would this be covered by your current insurance policies? Take a look at who you have classified as a supervisor, right? Do they do more than just occasionally assign work? Do they do more than responsibly direct other employees? Is there a way to structure their jobs so that they better fit that definition of a supervisor, right? Do some training to employees. I'm a big fan of training. I don't think you can expect folks to know what's expected of them if you don't tell them. So doing training about what an unfair labor practice is and how we respond to those could pay dividends. If you have an electronic use policy, take a peek at it, right? What does it say about cell phones and email and expectations of privacy, and who has access to those kinds of devices, and does it need to stay that way? If you have any form, settlement, or severance agreements where you have waivers written in, take a look at those and think about how they might need to be tweaked or changed. And then look at any arbitration agreements you have to see if it has any of those class and collective, right? To make sure that you don't fall on the wrong side. And so that if this becomes effective and is enacted, you're prepared for that. Now, I don't know that the PRO Act in its whole is going to be enacted because there is a lot in there that people might find objectionable. I think it is likely, if it does not move in the Senate, that we could see parts and pieces of these initiatives be brought separately, be tucked into other bills, or that we just could see rulemaking from the board to enact the same thing, right? So keep your eyes and ears open on those changes. We will certainly do the same and help keep you apprised of them. But I think some or all of these could come about in one way, shape, or form or another, although I am hopeful, I'm very hopeful, that it's not going to be all at once in the PRO Act, because that would be a significant overhaul. Which takes us to everyone's very favorite slide in any training, which is the last slide, which is when I say to you, questions, comments, concerns, good jokes.
So I don't see any in the chat. So if you have questions and you'd like to ask, feel free to unmute yourself or drop them in the chat for Kat to answer.
Like Jen said at the beginning, I'm going to have some notes in the notes section, but I will clean those out and we'll send this. When I created the PowerPoint, I tried to put, frankly, far more detail in the slides than I usually do, so it could be a good reference for you. So feel free, you can print it off, tuck it under your pillow, help give you nightmares at night the way it does me.
All right, well, I don't see anything, but again, we can share the slides with you and the recording to this, as well as Kat's contact information. So if you have questions after the fact, you can get in touch with her. Or if you have any ACI questions, again, Jordan put his email address in the chat as well. So feel free to reach out to him or I for ACI related things. But we will let you guys wrap up 3 minutes early. So again, thanks for hopping on with us and look for future webinars coming up here soon.
Hey Jen and Kat, one thing I would suggest, and maybe your notes, is just some bullet points and some potential. You identified in the training some unfair labor practices that we should train our supervisors on, maybe some bullet points on what specifically that would look like, some topics that we should be training our supervisors to be aware of what is an unfair labor practice, but what is not. So maybe that can be part of your show notes, as I say.
Absolutely, I can add a couple of slides then at the end on what a ULP is, and that's easily done.
Perfect, thank you. Thank you for your time as well, too. This was very informative.
Of course, my pleasure.
All right, thanks, have a good day, everyone.
Thank you, bye.